Ready, start. It was claimed that suit was also barred by Order 2 Rule 2 of CPC. The trial court rejected the application under Order 7 Rule 11 of CPC, Wide Order dated 7/1/2020, holding that on a plain reading of the plaint, it cannot be held that the suit is ex facie barred by limitation. Moreover, the question of limitation is a mixed of question of law and fact. Therefore, it would not be appropriate to reject the plaint under Order 7 Rule 11 of CPC. As regards the plea of suit being barred by Order 2 Rule 2 of CPC, the trial court held that the same can be decided as an issue in the suit. Aggrieved by rejection of their application under Order 7 Rule 11, the contesting respondents preferred revision before the High Court, which came to be allowed by the impugned order dated 27/1/2022. As the impugned order dated 27/1/2022 was passed ex parte inasmuch as none had appeared on behalf of the plaintiff in the revision, an application was filed for recall of the order dated 27/1/2022, which came to be dismissed by second impugned order dated 4/7/2022. Aggrieved by the aforesaid two orders, these two appeals have been filed. We have heard learned counsel for the parties and have also given liberty to the counsel for the parties to file written submissions. The learned counsel for the appellant submitted that the High Court committed a grave error in holding that the suit was barred by time. In holding so, the High Court observed that the suit was instituted after almost 36 years since culmination of mutation proceedings, which is incorrect inasmuch as mutation proceedings culminated on 27/2017 and the suit was instituted on 31/5/2019 within bracket, that is within 3 years thereof bracket close. In addition to above, it was contended that the suit was for possession based on title. Since the main relief was for possession, the limitation period would be 12 years from the date when the possession of defendants became hostile and adverse to the plaintiff. The High Court, however, failed to consider that aspect. Besides above, notice of the revision before the High Court was not served on the respondents, and therefore the first impugned order, which is an ex parte order, ought to have been recalled. On the strength of above submissions, the learned counsel for the appellant contended that it is a fit case where the appeals should be allowed and the impugned orders set aside. On behalf of the respondents, it was contended that predecessor in interest of the appellant had earlier instituted civil suit number 648/2012 seeking permanent prohibitory injunction to restrain the answering respondents from alienating the suit property. The said suit was dismissed on 17/5/2013 on the ground that there could be no injunction against true owner. Since the present suit is based on the same cause of action, the same is liable to be dismissed as being nothing but abuse of the process of law.